He's on page 12.
Good morning. We're here for the magistrates this morning, bond hearings. I need to go to page 12 for Peter Anderson. Where's he located?
Yes, he has family here, Judge, as,
Okay, thank you. Mr. Anderson, please come up.
He's approaching, Judge.
Good morning.
Good morning, Your Honor.
If you'd like to say something, please raise your right hand. Are you going to say something?
I will introduce myself. My name is John F. Bradley. I'm attorney for Vic,
Oh.
Mrs. Anderson, and the rest of the family, not Mr. Anderson.
Not for
No-
Peter Anderson.
No conflict.
Okay, very good.
Thank
So, no problem. Is there anyone who would like to speak to me
Yes.
today?
Mrs.
And
Anderson would like to speak, if that
if
meets.
she could raise her right hand.
Please do.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Okay, very good. Your name, ma'am?
Bernadette Anderson.
Okay, thank you, Miss Anderson. What would you like to tell me today?
I just want this to be dropped. I just want him to come home. This was just a very bad judgment, and I just need him to get home.
Would you like to tell the judge why that might be appropriate or important, Mrs. Anderson?
We've been married 55 years. I have no fear of this man at all. He's went through a hard time, and we are in a lot of stress. But I just want him to come home and work things out.
Can you tell the judge who lives in your house and how that might be appropriate to have him there, ma'am?
We are raising our 3 grandchildren, 5, 6, and 8-year-old children. We also have our youngest daughter living with us who is a cancer survivor and is going through serious medical issues and medical problems, and I need him home.
Ma'am, do you have the financial ability to bond or to be able to run the house without him
No.
there?
No. Okay.
Is there anything else that you think is important for the judge to know?
Just that, as I said, we've been married 55 years. We've never had, never had anything like this. But I just wanted to get him home and get it over with and get the problem solved.
Thanks for taking the time, Judge.
And thank you very much for being here.
and you and Mr. Anderson have raised 7 children together?
Now,
Well, and now you're also raising your grandchildren, and that was part of the stress that resulted in whatever took place?
Mr. Linder, I was going to ask you your position now you've heard from who the alleged victim is in the case, albeit the PC doesn't mention her age.
Yes.
That's
Your
true,
Honor.
too.
Well, I mean, I could, if the PD wants me to, I could ask her
I'm
age. She's
not
here
going to
present.
contest it.
Okay.
You're not contesting, okay, fine. Ma'am, are you over 65? Okay,
Your Honor, I'm going to be requesting a $1,500 bond and no victim contact. I do acknowledge the testimony provided by the victim at this time, but my concern is, I do believe a cooling off period would be appropriate.
what is his history?
There is no history, Your Honor. My concern is, we've got allegations that it appears out of frustration and anger, he's yelling at a child and throwing a crayon in the child's face.
Yeah,
According
that's
to,
what the child said.
Judge,
Anything else?
yeah,
I'll go, Judge.
well, I
I'm already
wasn't-
ready.
She observed that he was yelling at one of the grandchildren by her own statement that he cannot handle it anymore, raising the other grandchildren. The frustration led to her allegation that he slapped her in the face, Your Honor. She's already described it this morning as a stressful situation, and I am concerned that while it may not have happened before, according to this, it happened yesterday, and I am concerned about it happening again.
You know, I understand what Mr. Linder is saying,
I
Your Honor.
really am grateful that you want to tell me something, but I'm going to put him on pretrial release with ROR, calling in 2 times a week.
Okay.
I believe that's appropriate. He's allowed to go back to the home because she's not in fear of him, and I need him to help her. Obviously, they're both in a stressful situation. The last thing I want to do is put her in a situation by herself. But I do find probable cause for the arrest based on the fact that she's agreed that she's over 65 years old. And therefore, he will have to address the charges at a later time, but I am allowing him out. But he'll have to be on pretrial in order to, since they do own, ma'am, you have a home, he's lived here a long time?
Lived in our home 38 years.
Right, so I believe he's not a flight risk, and I believe that he will come to court and face the charges, and she can do whatever she wants in the way of maybe signing a waiver of any type of prosecution, whatever she has to do, and I'm grateful for everybody wanting to talk about the circumstance, but I pretty much understood it when I read the PC, as well as, of course, I thank you, ma'am, for being here, and I hope Peter Anderson is grateful for you being here, because it otherwise does look bad on paper, but life can be stressful, your circumstance can be stressful, and I'm giving you an opportunity, Mr. Anderson, to be out of custody, and I don't want you to do anything to violate any pretrial conditions. Please understand, this is something over the state's objection. They would like you to be on a bond, but pretrial release will keep tabs on you. You have to follow all their standard conditions, okay? Okay, any questions or concerns from anyone?
No, Judge.
Thank you, everyone. I wish you the best, truly.
Thank you,
Thank
Judge.
you. Thank you, Judge Powell. Thank you so much. Yes, thank you so much, yes. Not a problem. Thank you so much, everyone. Please deal with him and goodbye.
I'll turn it out. No, it's okay. Yeah. There's no paper for you.
I haven't been in a criminal court in 30, so I apologize.
No, that's okay.
I got a call a little while ago.
That's okay.
Everybody, thank you for your time.
All right, let's continue. Jennifer Monaco,
Judge, there are 3 people at the jail that they would like called out of turn.
okay.
Monaco's going to be a medical reset anyways. Your Honor.
Yeah, she's a
Monaco's
medical reset anyway.
reset, okay.
The 3 individuals from the main jail that they've requested to have called out of turn are on page 21, Mr. Winston, on page 20, Mr. German, and on page 24, Mr. Marshall.
Correct, Judge. Mr. German is on page 20, Judge. Mr. German, come on up, please.
All right, Mr. German is before the court. Today it's an add charge for burglary, unoccupied dwelling unarmed. And the court finds probable cause. I suspect Mr. German is in custody on other charges.
I'm
He
sorry.
is been held no bond, Judge.
Your Honor, if I could have one moment, I'm just looking for his paperwork.
Okay.
Your Honor, he does have a no bond hold for robbery with a firearm. He's got 2 other burglary dwelling charges where bond was set at $5,000 each, so I'm asking that this bond be set at $5,000.
That's what I was gonna ask for, Judge, considering he has a no bond hold.
All right, so the bond is $5,000. Dwight Winston,
Mr. Winston is here, present, Judge, at Maine. He is approaching, and Judge, he declined the services of public defender.
all right, Mr. Winston, you are before the court this morning. Charge 1 is robbery with a weapon. Count 2 is aggravated battery on a person 65 years or older. Count 3 is aggravated battery causing bodily harm. And 4 is resisting officer without violence.
Yep.
The court finds probable cause. Does the state wish to be heard?
Your Honor, I'm going to request a, excuse me, a $25,000 bond on 1, $15,000 bond on 2, a $10,000 bond on 3. Pretrial release of the GPS monitor, no victim contact. I'm concerned about the level of violence alleged in this matter, but also I don't believe, or I'm uncertain if Mr. Winston has any type of permanent address I would note that the address listed on the booking and the probable cause affidavits is the address for the Fort Lauderdale Police Department's headquarters. I have some other concerns that I think can't be dealt with today, but potential mental health issues, I suspect they may exist.
All right, Mr. Winston, do you plan on hiring private counsel?
No,
I'm sorry?
I want an attorney. I want a public defender.
Well, they told me that you've refused their
I ain't
services.
here. I ain't here. Good.
Judge, it seems like Mr. Winston changed his mind right now.
Okay,
Judge, may I have a moment then to speak with Mr. Winston, please?
sure.
Thank you, Judge.
It's such a big docket. We have to start. Start digging around. I know. You've got a lot of MOs, Mr. Shade. There's a lot.
I've left notes on
All right, then, is Mr. Horlick in the room? Should be an easy one. On page 2, Terry Horlick.
If you guys want
He's what?
are you guys handling?
She's been released? Okay.
Not possible.
They are ROR'd. All right. And then on page 3, do we have Erica Lovesmith?
Yes, she's in North Broward. Judge, she'd like to resolve her matters.
I mean, you don't
Oh, Ms. Lovesmith, was Ms. Lovesmith before this court recently?
Yes.
All right,
Within the last 2 months, I think.
okay. Is there an offer?
It was time served, Judge, with an admonishment that the next time is not going to be time served.
All right, Ms. Lovesmith, you're before the court today for 2 municipal ordinance violations. And I do remember you being before this court recently, so I'm going to impress upon you this time the importance of, these look like, are they panhandling charges?
Yes, Judge, they're carrying a sign in traffic.
All right, so ma'am, I'd like to say, tell persons, don't keep doing the same thing that keep giving you the same result, which is bringing you before the judge. All right? Do you wish to resolve your case today?
Yes, please.
All right, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Ms. Lovesmith, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that would prevent you from making a decision about your case today?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Ms. Lovesmith?
No contest.
Okay, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you, Your Honor.
Shanita Romero on page 3.
She's approaching, Judge. She's here.
Okay.
And Judge, whenever the court is ready, we're ready to proceed on Mr. Winston.
Okay, Ms. Romero, you're before the court for 2 municipal ordinance violations, and the court does find probable cause. What do you wish to do, Ms. Romero?
Resolve it today.
It's time served, Judge.
All right, the offer is time served, so do you understand that? You have to speak.
Yes, ma'am.
Okay, then please raise your right hand. You swear or affirm to tell the truth?
Yes.
You can put your hand down. Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Ms. Romero? Guilty or no
Guilty.
contest?
Guilty.
Okay, I accept your guilty plea, find that it's freely and voluntarily given, and your sentence is adjudication, time served. Good luck, ma'am.
Thank you.
Also on page 3, Lynette McKizzy.
Judge, the city of Hollywood would like this to go to the division.
Why is that? She has several.
Because of
Several priors?
the number of prostitution charges, the 3 different cases, and they're all cases. She doesn't have anything recent though, so that I have dealt with.
All right, so this is a 2018, 2000. Oh, it's all 2018.
Correct.
All right, Ms. McKizzy, you're before the court today for 3 misdemeanor cases on, these are all prostitution charges. Okay, and these cases were issued, there's one November 2018, January 2019, March of 2019. So the court finds probable cause. You do have a bond on each of these. I'm gonna leave the bonds in place and you can address this matter before your division judge. Okay?
Yes.
All right. Chesley Brimberry on page 7. All right, Ms. Brimberry, you're before the court. Charge 1 is a misdemeanor KPS. 2, 3, and 4 are felony KPSs not for magistrate with no bond holds. The court does find probable cause. You do have court tomorrow and on July 1st on your misdemeanor and division KPSs. So you'll see your division judges shortly, okay?
Okay, thank you.
All right. Terrence Howe on page 14.
Come on, Your Honor.
Time served, officer.
Where is Mr. Howe?
All right.
All right.
All right.
I got it, thank you. All right, Mr. Howe, this is charge number 10, it's an at-charge on a misdemeanor, it's a municipal ordinance violation matter. What is the status of Mr. Howe's other charges? Do we know?
Yeah, I believe it's
Mr. Howe, do you have other things holding you in custody, or is this the only thing that's left?
I don't know what charge this is.
This is lodging on city-owned property.
But you can still ask for her to increase the bond, which even though the judge
Okay.
considered 15. And the next guy is his brother,
Are those new arrests?
attempted first degree
There's
murder,
no,
even though the
is there any
judge
violation of probation or anything?
You're still gonna ask for no bond, proof of no presumption grade. You know,
Okay. All right, so, Mr. Howe, what do you wish to do with this charge?
Resolve it today if I can.
All right, what was the sentence on the offer on that
it'll be
one?
time served, Judge. He's been informed.
All right, so Mr. Howe, the sentence will be time served on this charge only, okay?
Thank you.
All right, then
Yes.
please raise your right hand so I can ask you some questions. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. Howe, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, Your Honor.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest, Your Honor.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you.
Brian Trala on page 14.
North Broward.
Thank you.
I'm served, Judge.
Did you give me this one?
All right, Mr. Trala, you're before the court for a municipal ordinance violation. What do you want to do today, sir?
No contest.
All right, all right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, Your Honor.
Okay, you can put your hand down. Do you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, Your Honor.
And have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would prevent you from making a decision?
No, Your Honor.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right. What plea do you wish to enter, Mr. Charla?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Thank you.
Mr. Shade, if you'll allow me to take
Go ahead.
this
That's
one
fine.
case that
Sure.
we were asked earlier to take out of turn.
problem.
So was that Dwight Winston?
Yes, Your Honor.
Okay,
Ready to proceed, Judge.
all right. So I've already informed him of the charges. The state has made some recommendations.
Yes, and the only other thing I'd want to advise the court, it does not appear that Mr. Winston has ties to the community. He has a lengthy criminal history out of the state of Connecticut, with the most recent disposition being January of this year.
Okay, all right.
Judge, that is correct. Mr. Winston's been now here in South Florida for the past 4 months. He relocated from Connecticut to down here to South Florida. Unfortunately, from what he advised me, he's not working. He receives disability. He gets approximately $995 per month. And unfortunately, he has no friends or family down here in South Florida, and unfortunately, he is homeless. When they asked him if he's in a position to post bond, he's not. He is financially indigent, and he has unfortunately no one to contact to help post his monetary bond. So for all practical purposes, there's nobody that's going to be able to help him out. So Judge, I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Winston. And I'm also going to ask you to sign an order so we can photograph his injuries, Judge.
All right, I'll sign the order. I don't know, there's a lot that seems to be going on here in this report. There are 2 alleged victims that, with injuries that Mr. Winston is alleged to have beaten with a wooden and or a metal cane. One victim was found naked in the street, bleeding. I don't know what's going on here. So at this time, based on the allegations that I have and the prior history that has been reported, I am going to impose a $7,500 bond on count 1, on count 2, 1, 2, and 3, $7,500. Okay, on each count. If Mr. Winston posts his bond, he will be on a level 2 GPS monitor. No victim with the, no contact with the alleged victims in this case. And no possession of any weapons or firearms.
Which was under better circumstances. they tell you what's going on with her?
No, no weapons or firearms, no contact.
I'm having outpatient procedure tomorrow, that's all. I'm trying to make it through every day, but
Okay.
this is a weird one.
All right,
All right,
let's go back to,
Kind of,
Justin Fontana on page 14.
it's with an
I'm sure.
object.
Please approach the judge.
Okay. All right, Mr. Fontana is before the court on a misdemeanor capias for alcoholic beverage violation. The court finds probable cause. Sir, what do you wish to do today?
No contest.
All right, I accept your no contest plea and your sentence's adjudication and time served. Good luck.
Thank you.
William Hennigan on page 15.
I'm sure. Just joking.
All right, Mr. Hennigan,
Yes, ma'am.
you are before the court on 14 misdemeanor capias.
Those are old, man. I was in the courtroom on Thursday, by the way, too. And they put me off till the 28th.
Well, these, I don't know how old they can be because they're all 2019 cases. And we're only in the 6th month of the year, so
Yeah, they've been taken care of already, though.
when?
I was told by the police officers I had 2 cases still pending. That was it. And I solved those already, because I was in the courtroom on Thursday.
Do we
How
have
many
any?
did you resolve on Thursday?
14 of them, actually, but they said there's still 2 more. And those are all misdemeanor cases, too.
Okay, hold on just a moment.
Yes, ma'am.
Scott Ferris.
Do we have any information that Mr. Hennigan resolved these cases?
I'll look, but I'll tell, Mr. Hannigan, as a friend of the court, has had a lot of cases.
Yeah.
Yeah.
It wouldn't be difficult
Yes, sir.
to confuse some with others.
All right, so Mr. Hennigan, because you have so many, you're gonna have to go before your division judge for us to determine which ones you've resolved, okay? All right, Timothy Odom on page 16.
That's fine.
All right, Mr. Odom, I see you're back again.
Good morning, Mr. Powell. Yes, ma'am.
Good morning.
The city of Pompano is not offering time served. Due to the number of times. that
All
Mr.
right,
Odom has appeared.
Mr. Odom, because of the number of your repeat visit, the offer today is not a time served from the city. Do you want to resolve your case today?
I would like to resolve the case today, Judge Powell.
All right. If you want to resolve your case today, it'll be 5 days in the county jail.
Can I set this for trial?
You can.
I did not. You know, I'm usually guilty of what I'm charged with. Yesterday, they come around with a van and just rounded about 5 of us up out of nowhere because we were walking across the street as a group, and they said that we were panhandling, and that was not the case.
Well, you know what? That's what you told me the last time you were before me. So I leave the bond in place and you can certainly fight this charge, okay? Because that was exactly what you told me the last time. Sean Young,
How about I take,
Sean Young on page 16.
North Broward?
That would be time served.
All right, Mr. Young, you have a misdemeanor KPS on a municipal ordinance violation for possession of paraphernalia. It looks like you did not show up for court on June 20th for your arraignment. The offer from the city at this time is adjudication and time served. Sir, what do you wish to do? What was the, okay, then, all right. You're raising your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Mr. Young, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, do you need any more time to speak with your attorney?
No.
Are you under the influence, no, I did ask you that already. Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
No.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Okay.
What plea do you, well, is that a yes or a no?
Yes.
Okay, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, your sentence is adjudication and time served. Good luck, sir. And do we have Cedric Greer today? No? Okay, he's on loan. And then do we have John Anthony? Oh, he's got other things on page 25. I don't, is Mr. Anthony in the room?
That's the last case you looked at.
Not if he's not in the room, we can just send that to the division.
Well,
Okay.
on John Anthony,
Yes,
he's got,
Yeah, he's got other matters.
yeah.
yeah.
So,
Rustin,
oh, okay, never mind.
yes, so,
I know.
that's all right.
All right,
Forgot that I have one there.
so,
Zach, could you print that out? Oh, hand me that, please.
we had pulled him out, so. Is Mr. Anthony in the room as yet? Anyone?
Judge, Your
Yes.
Honor, he said Broadway will be 5 minutes before he comes.
Okay, no problem. That's okay.
Thank you,
We'll-
Judge. I
We'll
appreciate
recall it.
Okay, recall it?
We will, yes.
Thank you.
All right. Oh, wow. Phone. All right, on page 11, we have someone signed in for Terrence Weaver.
North Broward, Your Honor.
All right. Someone here for Mr. Weaver? Do you wish to say anything? All right, Mr. Weaver is before the court this morning for aggravated battery causing bodily harm. It's domestic in nature. The court finds probable cause. I'll hear from the parties.
Yes, Judge, Mr. Weaver's wife, Michelle, is before the court.
Okay?
Shelby, that's my middle name. I just want him to come home to his family. He's a good man, hasn't been in trouble in years. And I'm concerned about his condition. He's supposed to be in dialysis this morning, but evidently he's missing dialysis. He's not gonna, get the dialysis on Saturday morning.
From what Mr. Weaver advised me, Judge, he's been a resident of South Florida all of his life. He's been living at the same location with his wife for the last 2 years. He has a job remodeling, which he's had for the last 8 years. He's never been to prison, and as his wife just pointed out to the court, he does require dialysis. Now, they have been in touch with a bondsman, and it's my understanding from speaking with Mr. Weaver and with his wife that they could make a $2,500 bond, and that's what we're going to be asking the court to set.
Okay?
Your Honor, and I understand that's what they're advising that they can afford, but I am concerned, based on the level of violence, injuries suffered by the victim in this case that were documented by the arresting officer. While Mr. Weaver's history is dated, he does have a prior domestic violence battery against a different alleged victim from 2003, 2001 grand theft auto with resisting without violence, 2000 possession of cocaine with intent to sell or distribute. Your Honor, taking into consideration testimony provided by the witness and the additional information, Your Honor, the state would be requesting a $7,500 bond and no victim contact.
I think that is going to be beyond the means of the family to post, Your Honor.
All right, at this time, I am going to impose a $5,000 bond. No victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, sir.
All
Yes,
right,
ma'am.
all right. All right, good luck.
Judge,
Yes.
there is one other gentleman that the deputies would like to have called out of order, and his name was Mr. Marshall on page 24. So whenever the court's ready.
All right, I'm ready.
Mr. Marshall, come on up, please. He's approaching, Judge.
All right.
How does that satisfy? Yes.
All right, Mr. Marshall is before the court on one charge of robbery with a firearm. And the court finds probable cause, and I'll hear from the parties.
Your Honor, the state is going to be seeking a finding of proof evident and presumption great and no bond hold. Your Honor, I provided the court defense counsel with the report. As you can see, the allegations would satisfy the elements. The evidence, as far as his identification, couldn't be much stronger. There was video surveillance of the incident where Mr. Marshall, his face was clearly seen. He was in possession of the firearm when the robbery was committed. He was identified by a law enforcement officer that previously was employed with the Department of Juvenile Justice that has had numerous encounters with Mr. Marshall, identified him with 110% certainty. He was then identified by the victim with the surveillance photos, who identified him with 100% certainty, saying he would never forget his face. And ultimately, he was identified via the surveillance photos taken from the robbery by his own mother.
Okay?
We would object to the court making a finding of proof evident presumption great at this point. The state has not produced any of these videos of Mr. Marshall allegedly committing these crimes. That's their responsibility to do that if they want to meet that very high burden of proof, but they failed to do so. They're relying entirely on a supplemental report that's not supervisor approved, written by a detective who witnessed none of the events that transpired. So we would ask this court at this point in time to make a finding that their state has failed to meet their burden of proof evident presumption great. There's supposedly this photo lineup, which has also not been presented to the court. There's a video of Mr. Marshall clearly in possession of the gun, which, again, not presented to the court. There's identifications made by witnesses who are not presented to the court. Nothing has been presented to the court. And so we would ask that this court not make a finding of proof evident presumption great. We would ask the court to set bond for Mr. Marshall, and if over our objection the court does find proof evident presumption great, we would ask the court to use its, exercise its discretion and set bond for Mr. Marshall.
All right, based on the probable cause affidavit and the supplemental report, the court does find probable cause and further makes a preliminary finding of proof evident presumption great. And this is without prejudice for Mr. Marshall to have a bond hearing before his division judge based on state v. author. And Mr. Marshall will be held no bond until further order of the court.
Just request an order of no victim contact and an abundance of caution, please.
Right. Mr. Marshall, no victim contact with the alleged victim in this case.
Okay. I'm sorry, I gave her paperwork.
Okay.
Okay, here, I'll print stuff out.
All right, the Spanish interpreter is here.
Yes, the Spanish interpreter, thank you for reminding me, Judge. The Spanish interpreter is here.
Who needs a Spanish interpreter?
There's 3 individuals here at Maine so far that I've spoken to that require Spanish interpreter. 2 individuals on page 22, Mr. Ernesto Gonzalez, Mr. Pedro Gonzalez, and on page 35, Judge, Mr. Yurandi Shaviano. So the first gentleman, Mr. Ernesto Gonzalez, Mr. Ernesto Gonzalez is approaching, Judge.
What was the name of the last person?
Should be the last page you have on the docket, Mr. Yurandi
Okay.
Schiaviano.
Okay.
Oh, and Mr. Schiaviano, Judge, just to let the court aware, he informed us that his family hired a private attorney. I believe my colleague contacted Mr. Reedy. Mr. Reedy, I believe, is trying to get in touch with his family, find out.
Yeah,
the
we're
name
trying to
of
find out who that is right now.
Okay, thank you.
I already gave this to the judge.
All right, you've been, do you swear affirm to translate from Spanish to English, or English to Spanish?
I do, Your Honor. For the record, Igor Felicioni.
Good morning, Mr. Felicioni.
Good morning, Your Honor.
Ernesto Gonzalez,
Ernesto González,
you're before the court today, sir.
usted se encuentra hoy frente a la corte.
The charge, I'm making a probable cause finding for attempted murder.
Hago un hallazgo de causa probable para el cargo de tentativa de asesinato.
Okay, and I'll hear from the parties.
Y en este momento escucharé de las partes.
Your Honor, I'm going to be requesting a $50,000 bond, pretrial release of the GPS monitor, no victim contact, no possession of weapons. Your Honor, I believe that bond and release condition, I'm sorry, Igor, I'm sorry. You know I'm usually good about that.
Don't worry about it, I got you. Su señoría, en este momento vamos a pedir una fianza de $50,000 con las condiciones de liberación previas al juicio de un monitor GPS, una orden de no tener contacto con la víctima y no poder poseer armas.
Your Honor, I believe this bond and release conditions are appropriate based on the aggravating circumstances of this case.
La Fiscalía cree, su señoría, que esta fianza y estas condiciones son apropiadas especialmente a la luz de los elementos agraviantes de este cargo.
According to the victim and multiple witnesses in this case, this attack was unprovoked, and the victim was in the process of backing away from the defendants at the time of the attack.
Según la víctima y múltiples testigos, este ataque no fue provocado. De hecho, la víctima estaba retrocediendo, alejándose de los acusados.
It wasn't until the victim, while backing up, stumbled over a speed bump and fell to the ground that the co-defendants decided to attack him when he was defenseless.
No fue sino hasta que la víctima se tropezó y se cayó cuando los coacusados decidieron atacarlo en un momento en que la víctima se encontraba indefensa.
Mr. Gonzalez handed his brother the knife and told him to kill the victim prior to his brother stabbing the victim.
El señor González le entregó el cuchillo a su hermano y le dijo que matara a la víctima antes de apuñalar a la víctima.
Nothing further, Your Honor.
Más nada, su señoría.
Does Mr. Gonzalez have a criminal history?
Fiscalía, ¿el señor González tiene un historial criminal?
I'd have to rely on pretrial, Your Honor. He's not in my database.
Tendríamos que confiar en la información de la oficina de pretrial porque no lo tengo en la base de datos.
Yes. I don't have any, I don't know of anything.
Judge, we can't hear.
So you just have to be the same.
2006, he was arrested for aggravated battery. It seems to be domestic related. He will have received a withheld for battery.
En el 2006, el señor fue arrestado por agresión física agravada en un incidente doméstico y recibió una retención de condena por agresión física.
No additional priors.
Y no tiene antecedentes adicionales.
Okay.
Judge, and speaking of Mr. Gonzalez, he is aware that the bond that he came with, is $15,000, but he's not in a position to post that bond.
Hablando con el señor González, él está al tanto de que la fianza es de $15,000, pero él no está en una posición de pagar esa fianza.
Judge, he's 47 years old and been living in our community for over half of his life, 25 years.
El señor tiene 47 años de edad y ha estado viviendo en nuestra comunidad por más de la mitad de su vida, 25 años.
Now, he lives in Miami in a house they rent with him, his brother, and his girlfriend.
Él vive en Miami, en una casa que rentan él, su hermano y su novia.
Judge, my understanding is he is self-employed. He does construction for a living.
Entiendo que el señor trabaja por su propia cuenta en construcción para ganarse la vida.
He's been doing that for now 14 years now.
Y ha estado haciendo eso por 14 años.
My understanding is he makes approximately $2,000 a month, Judge.
Entiendo que el señor produce $2,000 al mes.
However, in speaking to Mr. Gonzalez, from what he advised me, he has no money in the bank. He owns no property.
Y hablando con el señor González, él me indicó que no tiene dinero en las cuentas bancarias ni propiedades.
Judge, from what he advised me, his girlfriend is working. She's a hairdresser by trade.
Su novia, sin embargo, sí está trabajando. Ella es peluquera.
Keep it at those amounts.
We're going to be asking, we don't have no objection as far as Mr. Gonzalez being supervised. We'd be asking for pretrial release, but with a $5,000 bond.
No tenemos objeciones con que el señor González esté bajo los términos de supervisión antes indicados de pretrial, pero vamos a solicitar que la fianza sea fijada en $5,000.
Also, we're going to be requesting a property order. He believes in his wallet. He has the phone number that he can call to get in touch with his family.
También vamos a solicitar una orden de acceso a su propiedad. Creemos que en su cartera tiene el número telefónico para accesar a las personas necesarias.
All right, the court having reviewed this probable cause affidavit, seems like there was a joint effort based on the allegations in this, based on the allegations in the affidavit to arrest, to attack the alleged victim. At this time, the court finds probable cause. The bond will be $15,000. That's going to include a level 2 GPS pretrial and no victim contact, no weapons or firearms.
Ok, considerando lo que se dice en la causa probable, pareciera que esto fue un esfuerzo llevado a cabo en conjunto sobre la supuesta víctima, tal y como indica el reporte del arresto. Por lo tanto, la corte halla que hay causa probable y la fianza queda fijada en $15,000. Adicionalmente, supervisión nivel 2 con un GPS y una orden de no tener ningún tipo de contacto con la víctima, así como también de no poseer armas de fuego o de cualquier naturaleza.
Okay, Pedro Gonzalez.
Señor Gonzalez, Pedro? He's approaching, Judge.
Okay. All right, for Pedro Gonzalez, the court does find probable cause for attempted murder with a deadly weapon.
Para el señor Pedro González, la corte halla que hay causa probable para el cargo de tentativa de asesinato con un arma letal.
Your Honor, and he has been, well, at least arrested for attempted murder in the first degree.
Which one?
Pedro Gonzalez.
Su señoría, la fiscalía indica que el señor Pedro González ha sido arrestado por tentativa de asesinato de primer grado.
It's alleged he is the co-defendant that actually stabbed the victim with the knife.
Se alega que él es el coacusado que efectivamente apuñaló a la supuesta víctima con el cuchillo.
The state would be seeking a finding of proof evident or presumption great and a no bond hold for first appearance purposes.
La fiscalía quiere que se haga la presunción de prueba evidente, superando la presunción mayor, y que haya una retención sin fianza.
If the court does not find proof evident or presumption great, or does and chooses to exercise Your Honor's discretion in setting a bond,
En caso de que la Corte hallara o no hallara prueba evidente, presunción mayor, y quisiera ejercer su discreción y fijaré una fianza,
the state would be seeking a $75,000 bond, pretrial release of the GPS monitor, no victim contact and no weapons.
la Fiscalía en ese caso solicitaría una fianza de $75,000 con condiciones de supervisión de GPS, de monitor GPS, orden de no contacto con la víctima y orden de no poseer armas de ninguna naturaleza.
We would have no objection to the state's request that there be no contact with the victim.
Nosotros no tendríamos objeción con la orden de no tener contacto con la víctima.
However, we would object to a finding of proof evident presumption great at this stage.
Sin embargo, sí estamos en objeción en que se solicite un hallazgo de prueba evidente presunción mayor en esta etapa del proceso.
While I do understand that Mr. Pedro Gonzalez's situation
Entiendo la situación del señor Pedro González
is not the same as Ernesto Gonzalez's situation,
y que no es la misma a la del señor Ernesto González.
I would note that the court did set a $15,000 bond for Ernesto Gonzalez.
Yo indicaría que la Corte fijó una fianza de $15,000 para el señor Ernesto González.
And the presumed bond for Pedro Gonzalez
La fianza para Pedro González, entonces,
is the same $15,000.
debería ser la misma, $15,000.
And that is the bond that we would ask this court to impose at this time.
Y esa es la fianza que nosotros le solicitaríamos a la Corte que impusiera en este momento.
It seems inconsistent to me
Nos parece inconsistente
that the bond for one defendant should be so disparate and so different than the bond for the other defendant.
que la fianza para un acusado sea tan diferente a la del otro acusado.
And for those reasons, we would ask the court to set bond appropriately for Pedro Gonzalez
Por tal razón, le pediríamos a la Corte que fijara la fianza apropiadamente para Pedro González,
not to make a finding of proof evident presumption great,
que no se haga un hallazgo de prueba evidente presunción mayor,
and whatever other special conditions this court felt were appropriate,
y que impusiera cualquier otra condición que esta Corte considerase apropiado.
Pedro Gonzalez would be more than happy to agree with.
El señor Pedro González estaría feliz de estar de acuerdo con eso.
Your Honor, I would just note, Mr. Reedy has argued many times before this court in cases where, for instance, if there's a crime committed with co-defendants and a weapon is involved,
Su señoría, en este momento la Fiscalía quisiera alegar que el abogado señor Reedy ha argumentado muchas veces frente a esta Corte en crímenes en los cuales hay múltiples acusados con y uso de armas,
where if his client was the co-defendant that wasn't in possession of the weapon, that should be considered a mitigating factor.
en caso de que su cliente fuera el coacusado que no tenía el arma, eso debería ser considerado como un factor mitigante.
Following that same exact line of reasoning, certainly it should be considered an aggravating factor if Pedro Gonzalez is the one that actually used the knife against the victim.
Siguiendo esa línea de razonamiento, indiscutiblemente el hecho de que el señor Pedro González fue quien utilizó el arma, eso debería ser considerado como un factor agravante.
By very brief way of rebuttal, Judge. By very brief way of rebuttal, Judge.
Una breve respuesta, su señoría.
Both of the co-defendants were in possession of the knife at one time or another.
Los dos coacusados estuvieron en posesión del cuchillo en un momento u otro.
It also appears as though they gave the knife, or one of them gave the knife, to a third person who entered the residence.
También aparentemente le dieron el cuchillo a una tercera persona que entró a la residencia.
And that knife was never recovered.
Y ese cuchillo jamás fue recuperado.
And what I may have argued in other cases under other circumstances
Y cualquier cosa que yo pudiera haber argumentado en otros casos y bajo otras circunstancias
has no relevance to what's being decided before the court now.
no tiene ninguna relevancia con respecto a lo que está siendo decidido el día de hoy.
Okay, I'm ready to make a ruling. I do realize that Mr. Gonzalez is charged with a greater crime. Pedro Gonzalez is charged with a different crime from Ernesto Gonzalez. However, at this time, I will not make a finding of proof evident presumption great. There does appear to be some conflict in who actually did the stabbing. So based on that, there are also witnesses who said that they did not see the stabbing. So at this time, I do find probable cause. I am going to impose a $15,000 bond with the level 2 GPS for pretrial, no contact with the alleged victim, and no weapons or firearms.
Ok, en este momento la Corte está lista para tomar una decisión. Si bien es cierto que al señor Pedro González se le acusa de un crimen más grave que al señor Ernesto González, en este momento la Corte no hará un hallazgo de prueba, evidencia o presunción mayor. Hay conflictos aparentemente sobre quién cometió el apuñalamiento efectivamente. Varios testigos dijeron inclusive que no habían visto el apuñalamiento y por lo tanto, vistas estos conflictos, voy a fijar la fianza en $15,000 bajo las mismas condiciones nivel 2 de liberación previa a juicio. Tendrá que tener un monitor GPS, no podrá tener contacto con la supuesta víctima y no podrá poseer armas de ninguna naturaleza.
All right. Okay, have we determined
Is there an issue with the?
anything about Yolanda Chaviano?
Oh, no, Judge. But if you give me a moment, I'm going to try to call his parents. I think they may know who it is, but I don't see any.
Okay.
All right.
He informed me that I believe his father hired him yesterday, Judge. I think he remembers, he believes the last name of the attorney is Savino.
Do you want to at least ask him in Spanish if he knows the name
Señor, ¿usted conoce el nombre de su abogado?
of the attorney?
No.
All right. Does he know when his family spoke with the attorney?
¿Usted sabe cuándo su familia habló con el abogado?
Hace ya como un mes. Supuestamente me habían traído para soltarme con el GPS y ahora me encuentro con que tengo contra.
About a month ago, I was supposed to be here. They were bringing me here to let me go with a GPS, and now I find myself in this situation.
So when did your family speak to an attorney recently about this arrest?
Su familia habló con un abogado recientemente acerca de este arresto.
Ayer hablaron, pagaron mi fianza ayer.
Oh, you know
Yesterday,
what?
they paid my fine.
This is a change of charge. Is that correct, Mr. Linder?
Esto es un cambio de cargo.
It's another technicality.
It looks like it's a change of charge.
You know, it is a change of charge, albeit a technical one.
Es un cambio de cargo, pero aparentemente es uno técnico.
All right, so then we can proceed.
Podemos proceder.
So under what was the release conditions then?
On this charge, you set a $20,000 bond with a GPS monitor, passport surrender, and Nebbia full collateralization holds.
Okay.
What was that last thing?
Nebbia and full collateralization.
Interpreter would like to get a clarification. What is Nebia? What's the name of a person? Okay. En este momento la Fiscalía solicita una fianza de $20,000 con liberación con GPS, entrega de pasaporte y una colateralización completa para Nebbia.
So, sir, so now I understand you are correct that you were before the court before and was supposed to be released on bond and GPS monitor.
Señor, Hablando con los abogados, usted tiene la razón. Usted tenía que estar acá para ser liberado bajo fianza y con un monitor GPS nivel 2.
So this is a technical change in the original charge that you were before the court on.
Y entonces esto es un cambio técnico en el cargo en el que usted se presentaba frente a la corte anteriormente.
Before, the charge was burglary, unoccupied structure, unarmed, across county lines.
Antes el cargo era robo de un sitio desocupado alrededor de líneas del condado.
And now we've removed the across the county lines portion.
Ahora hemos removido la porción de las líneas del condado.
Okay? So at this time, I am going to leave the previous conditions that were in place.
En este momento voy a dejar las condiciones previas que estaban fijadas.
So you have the same amount of bond and the same requirements for GPS and passport surrender.
Entonces tiene los mismos requisitos de fianza y de GPS y de entrega de pasaporte.
Okay?
Okay?
Nothing.
Ya entregué el pasaporte y todo, ¿sabes? Supuestamente me iban a aceptar hoy.
But I already surrendered my passport.
That's
They
fine.
were going to let me go today.
That's fine. So you should be able to be released today.
Sí, eso está bien. Usted debería ser liberado el día de hoy.
Gracias.
Thank you.
If that's,
Was getting to be a full collaboration.
well,
So that's,
if they had a hearing, I
yeah,
don't
no,
know.
if his judge signs off on it, obviously,
Okay.
then.
All right? Okay, good luck, sir.
Muy bien, buena
And
suerte, señor.
I do have the number for his lawyer,
Ya,
and I will call his lawyer and let his lawyer know what happened here this morning.
Okay.
Also, North Broward and Conte both require the services of the Spanish interpreter.
North Broward and Conti, what?
Require the services of the Spanish interpreter.
Okay. North Broward, who do we have that needs a Spanish interpreter?
Sotolongo, page 22.
Yeah, so I don't. Oh, let's see, because the bond.
Okay. Is that the only person at North Broward that needs a Spanish interpreter? Okay. All right. Dan Sotolongo.
Dayan Sotolongo.
Sir, you're before the court today for one count of grand theft.
Señor, usted está frente a la corte el día de hoy por un cargo de robo de cuantía mayor.
Count 2 is a misdemeanor capias.
El cargo número 2 es una infracción de orden de captura.
And count 3 is a felony capias with a no bond hold not for magistrate.
Y el cargo 3 es una orden de captura, retención por un delito mayor que no se encuentra bajo la jurisdicción de un magistrado.
The court finds probable cause,
La corte halla causa probable.
and the standard bonds will remain in place.
Las fianzas estándar permanecerán vigentes.
And as I said before, he does have a no bond hold on count 3.
Como dije anteriormente, él tiene una retención sin fianza por el cargo número 3.
He will be before his division judge tomorrow at 8:30 on the felony charge.
Usted se presentará frente a su juez de felonía el día de mañana a las 8:30 de la mañana por ese cargo.
And on the misdemeanor charge, he has a court date for July 1st.
Y en el cargo del delito menor, tiene una fecha de corte de 1 de julio.
Okay, good luck, sir.
Buena suerte a usted, señor.
All right, who, at Conte?
Yes, there is one at Conte. I'm sure Deputy Sanchez can enlighten
Who
us
do we
as to
need
who that is.
for the Spanish interpreter?
Page 35, William Baez Cartella.
Okay. All right, William Baez Cartella.
William Baez Cartella.
Sir, you're before the court today for a change of charge on the case that you previously came before the court on.
Señor, usted está frente a la corte para un cambio de cargo por el caso que estuvo previamente frente a la corte.
When you were originally arrested, the charge was burglary, unoccupied structure, unarmed across county lines.
Cuando fue arrestado originalmente, fue arrestado por un robo de una morada desocupada atravesando líneas de condado.
And now they've just changed it to remove the portion about from across county lines.
Y ahora lo han cambiado y le han removido la porción del cargo de las líneas de condado.
How much bond was Mr. Baez Cartaya originally on?
¿Cuál era la fianza original del señor Báez, Fiscalía?
Your Honor, he is the co-defendant of the gentleman you just called last.
Okay.
You would set the same bond and release conditions, 20,000 with the same release conditions.
Okay.
El señor es el coacusado del caso que llamamos anteriormente en la cárcel principal. Se habían fijado las mismas condiciones de fianza, $20,000, y las mismas condiciones de liberación previa.
And the previous defense motion to modify was denied by Judge Weeks.
Y la petición de modificar de la defensa fue negada por la juez Weeks.
All right, so Mr. Baez Cartala, the previous conditions of bond and release conditions will remain in place.
Señor Báez, las condiciones previas de fianza y de liberación permanecerán en efecto.
And as,
Dile que desde el día 10 de este mes, la fiscalía tiene la media mía con todo para aprobarla, pero no sé por qué no la han leído.
Please tell her that on the 10th I gave the prosecutor everything that they need to prove it, but they haven't said anything.
okay. All right, I don't know, I'm not sure what that means.
Señor, no entendemos qué quiere decir usted con eso.
He does,
And Your Honor,
Señoría,
if he's referring to the Nebbia collateral packet,
yes.
that would be up to his attorney to file the motion before the court.
señor, si usted se refiere al paquete colateral de Nebbia, eso va a depender de su abogado, el procesamiento de eso.
Es que el abogado la entregó el día 10 de este mes. Tú sabes, ya la media se hizo el día 10 de este mes. Llevo 17 días que la fiscalía tiene la media para que me diga sí o no, tú sabes.
Okay. My attorney sent it on the 10th. And to the prosecutor. I've been 17 days waiting for the prosecutor to tell me if yes or no, you know?
Okay, well, his attorney needs to take the appropriate action.
Entonces, señor, su abogado es el que tiene que tomar las acciones apropiadas.
Okay, thank you.
Muchas gracias.
Is there anyone else who needs a Spanish interpreter? It's 20,000. Yeah. And he's got, okay. Anyone else? Nobody is responding.
All right.
All right, thank you.
Your Honor, North Broward has a case they would like to have called out of turn. It's that kind of day.
All righty.
Yeah, give me 1 second, Igor, I'll get it right for you.
Okay, what
Uh,
case is this?
Page 13, Romero Pierre.
That's at North Broward?
Yes, ma'am. Those last two guys? Okay, you got it.
All right, Mr. Pierre? You are before the court this morning for one count of aggravated assault with a deadly weapon, domestic, and count 2 is touch or strike battery, also domestic. And the court finds probable cause. And I'll hear from the attorneys.
Your Honor, the state is going to be requesting a $10,000 bond on count one, a $2,500 bond on count two. In order of no victim contact, I would note, he was arrested last year for domestic violence, aggravated assault with deadly weapon against a different alleged victim. He ended up pleading it down to improper exhibition of a weapon. January of this year, was placed on 4 months probation and just got off probation, looks like May 10th of this year. I would also note one of the conditions of his probation was that he must continue any and all mental health treatment and must take all medications as prescribed.
Okay.
Yeah, I'm very concerned about Mr. Pierre because he would not speak with me. And, looking through his history and reading about his medical condition in the probable cause affidavit, I really can't tell you very much about him because he would not, he hung up on me, basically.
Okay.
I do notice that we have represented him on a number of prior occasions. There has been indications of hospitalization. I think there are mental health issues involved. I'm going to be asking our office to look into those issues. But I don't know what he can afford for bond, if anything.
Okay. All right, at this time, I am going to impose a $7,500 bond on count one and $2,500 on count two. No victim contact until further order of the court. Okay, Mr. Pierre, do you understand that?
Yeah, I understand everything.
Okay, all right, good luck, sir.
Thank you. I know, yes.
All right. Can we go back to our normal proceeding?
Your Honor, I'm sorry, there was one other case that I did have.
No? I guess the answer is no.
Well, no, I don't know if you got the sign-in sheet, Your Honor, that, I have a detective here who needs it signed in.
Which one, on which one?
Jorge Martinez.
Okay. These Thursday mornings are always unusual. Okay, Jorge Martinez. He's on page 30.
So is he there, Hector?
He's here, Judge, and we're gonna waive formal reading of the charge.
Okay. All right, so at this time, the court does find probable cause as to the 3 counts presented, and I will hear from the parties.
Well, Your Honor, I'm going to elicit some testimony from the detective.
Okay. Now, raise your right hand. Is you affirmed to tell the truth?
I do, ma'am.
And you can put your hand down and please state your name for the record.
Detective Mark Moretti, the Miramar Police.
What's the last name?
Moretti.
Moretti, okay. All right,
Thank you, Your Honor. Very briefly, Detective Marty, who are you employed by and in what capacity?
City of Miramar detective.
And what department, what division?
I work homicide.
Okay. And how long have you been a detective?
About 6 years.
You were involved in the investigation of Jorge Martinez for the charges he stands before the court on today?
Yes.
Okay. Are you familiar with the probable cause affidavit that was prepared by an officer, Hector Bertrand, in this case?
Yes.
Okay. Other than what's in the probable cause affidavit, is there any additional evidence of regarding, and I'm sorry, Your Honor, but I have to mention the charge for the record purpose, question for the sexual battery against the victim?
The Yeah, as you could read in the probable cause affidavit, Mr. Martinez live streamed some of the activities, the illegal activities mentioned in the affidavit. We recovered additional video late last night, of furthering the act that's mentioned in the affidavit, the sexual battery of a minor, and it was live streamed, and we recovered it. It was digital penetration. And I also want to add further on the status of the victim, if I can at this point.
It's up to you.
I informed her about the new information as well. I want to inform her the status of the victim.
Yeah, no, that's what's going to be my next question. If you could advise the current status of the victim.
The victim is currently in coma in a location in Dade County in pediatric care, emphasis on the pediatric due to her age. We're not sure that she's going to make it or not. She was without oxygen to her brain for about 28 minutes, organ failure, internal bleeding. The defendant and other associates could have taken her to a hospital much closer, minutes away. They chose to take her to a hospital an hour away in rush hour traffic into Dade County, which probably contributed to her accelerated status. At this point, we do not know if she's going to make it or not.
Thank you, Detective.
Thank you.
Your Honor, Mr. Martinez has a juvenile history. He's 18. It does include priors for battery, grand theft auto. But frankly, I think, and my requests are going to be based on the aggravating nature of these allegations. Your Honor, you're familiar with the allegations. They speak for themselves. I'm obviously concerned for the victim, who is in the current medical status, as Detective already advised the court, but other minors in the community. Your Honor, I'm going to be requesting a $250,000 bond on count 1, a $50,000 bond on count 3, a $50,000 bond on count 2, no victim contact, no contact with any minors. Should he post these bonds, pretrial release with a GPS monitor level 1.
How much bond were you requesting, Mr. Linder?
50.
Judge, I understand that the allegations are very, very serious. I'm going to first be requesting a photo order. Second, Judge, as you heard, Mr. Martinez just basically turned 18 this year. He's unemployed. He is with his mom. His mom has 2 jobs, Judge. She works at a factory and she cleans basically for a living. So, Judge, I'm asking you to take that into consideration.
All right. This probable cause affidavit is quite concerning, and there is great concern for the community. The allegations are that a 15-year-old was given drugs and then assaulted, plus videotaped, and then even in the report said that when she was found, that her lips were blue. And based on the testimony from the detective at this time, the court finds probable cause. At this time, I'm going to impose $250,000 bond on count 1, $50,000 on count 2, $250,000 on count 3. This will be with a level 1 GPS. No victim contact, no contact with minors. Okay. All right, on page 18, we have Jeffrey Dixon. Good morning, ma'am.
Just
right.
what pages, Mr. Dixon?
Mr. Dixon, I'm sorry, is on page 18,
Thank you, Judge.
and I believe his mother is here. Is that correct, ma'am? All right. All right, Mr. Dixon is before the court on one count of possession of cannabis 20 grams or less. When the court finds probable cause. Does Mr. Dixon have any priors?
Good morning, Your Honor. Will Resnick on behalf of the state of Florida. He has no priors, Judge.
Okay. He has a bond for $100, ma'am. Can you afford that? All right, so we'll leave the bond at $100, okay?
Since he has no prior record, if the mom hasn't gone to the bondsman yet,
Did you go to the bondsman yet?
would you consider an ROR if the
All
state
right.
doesn't have an objection?
No objection,
Thank you,
Judge.
All right, I'll grant the ROR. So you don't have to post the bond, that's what that means? He's being released on his own recognizance. He has to pay attention to the mail so that he knows when he has to come back to court. Okay? All right, good luck, ma'am.
Thank you.
All right. Bridget Sorling.
She's approaching, Judge. She's here at Maine.
Ma'am, you're before the court on 2 misdemeanor cases, and these were issued June 4th. Looks like you did not show up for a hearing, June 4th and June 12th.
Oh, these are county ordinances, Judge.
So, ma'am, what do you wish to do with these cases?
What'd she say?
What do you wish to do today?
Resolve them today, please.
All right, ma'am, if you wish to resolve your case, the sentence will be adjudication and time served.
Yes, sir. Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand everything that's going on here today, ma'am?
Yes, ma'am.
Is anyone forcing you to resolve your case? Are you under the influence of drugs or alcohol?
No, Your Honor.
And do you need any time to speak with an attorney?
No, Your Honor.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
Okay, what plea do you wish to enter, Ms. Sorling? Guilty or no?
contest.
Okay, I accept your no contest plea. Find that it's freely and voluntarily given, and you're sentenced to adjudication and time served. Good luck.
Thank you very much.
You're welcome. Melissa Slug.
North Broward, Judge.
Thank you. Ms. Slug, you're before the court on a misdemeanor capias for a petty theft charge.
Yes, ma'am.
And the court, what do you wish to do today, ma'am? It looks like you did not show up for your arraignment on June 20th.
Yes, ma'am.
So, what do you wish to do with your case today?
Settle it if possible.
It's a municipal ordinance. All right, it is a petty theft, and if the state doesn't mind, do you have the police report on this?
No, no, this is,
I
think-
know.
No, I don't know if I have it anymore.
Oh, okay.
Sorry.
All right,
Sheila, do you have a copy of the report on this case? Slug.
on Slug.
Page 3.
All right, All right, Ms. Slug, if you wish to resolve the case today, I'll sentence you to adjudication and time served.
Thank you, ma'am.
There's no one here to prosecute the case, and I don't have the information as to whether or not there are any restitution or anything, so, please raise your right hand.
Doesn't appear to be any restitution.
Oh, okay, thank you. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ms. Slug, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, no, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
Guilty.
Well, I see you shaking your head, so your options are guilty or no contest.
No contest.
All right, so I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you, ma'am.
All right. Lanisha Bullard.
She's approaching judges here at Maine.
Okay. All right, Ms. Bullard, you're before the court this morning for one count of grand theft. Count 2 is felony violation of probation with a no bond hold. Count 3 is violation of probation also with a no bond hold. The court finds probable cause, and your bond on count 1 is $1,000. You do have court tomorrow before your division judge, okay? Elizabeth Chacon.
She's here present, Judge at Maine.
All right, ma'am, you are before the court on one count of resisting officer without violence. Count 2 is escape or attempt to escape. And count 3 is a municipal ordinance violation. The court finds probable cause. And I'll hear from the parties as to bond.
Your Honor, on count 2, the state would be seeking a $5,000 bond. There's no ties to the community here. She's born in Colorado. Her permanent address is Colorado. There's also a concern about future appearances at court dates. She has an active capias, and the allegations of this case where she was sitting on a bench while the officers were conducting a criminal investigation and got up and ran from the scene.
And did you say priors?
We can pull those. Your
1 second, Judge.
Okay.
Yes, Judge. Out of the state of Colorado, 2017 DUI with a hit and run, and there was a failure to appear on that case.
All right. Sir Romero?
Judge, in speaking with Ms. Chacon, she does not know why, what the criminal investigation had to do with her. However, having said that, Judge, she isn't working. She's from Colorado, specifically from a place called Loveland. My understanding, she was down here. Her and her boyfriend wanted to visit South Florida, her husband, rather. My understanding, Judge, is she is not working. She is on disability. She gets approximately $900 per month. From what she advised me, she really has no one to contact to help post her monetary bond. She has no sort of friends nor family. It's basically her and her husband. Now, my understanding, Judge, she does not have any money in her property. She's asking the court to consider releasing her on pretrial release. Now, I did speak to her. I believe she gets her disability payment, I believe, on the 1st of the month, or 3rd of the month, rather. But at this time, she has no sort of funds. So, Judge, we're asking for Ms. Chacon to be considered released on pretrial release.
Is that 2017 case, did you say it's been resolved? Okay. All right, I'll release Mr. Khan to pretrial supervision, okay? Yes.
Okay, with her having a Colorado address on there.
Okay, all right. Ask the question, don't, it sounds like you were just on the attack.
No.
What's the
The
question?
question is, with her having a Colorado address, how's that gonna work with her being on standard supervision? Because she's gonna have to remain in the Tri-County area unless there's a court order granting permission for her to go, to leave the area.
And that is true, Judge. With standard pretrial, it is within your purview, and it's been done many times when people live out of state that they could report by phone. So that's not an impediment or anything like that at all, Judge.
It's just not done very often when the allegations are that people run from the police when they told that they're being investigated.
She can, she'll be able to call in. This was a sleeping on the beach. It started out as a sleeping on the beach case, so, okay? I'll sign the order. Lisa Calvert.
Mr. Reedy?
Hello, good morning.
All right, Ms. Calvert, you're before the court on one count of possession of alprazolam. And
Yes,
the court finds probable cause. All right, let's hear from the parties in regards to Ms. Calvert. All right,
You make $1,000 bond, ma'am?
No, sir, I cannot at this time.
does Ms. Calvert have priors?
One moment, Judge.
What's the issue, Michelle?
I mean,
How long have you been living where you live now?
I've been in Florida for almost a year. And I came down here for surgery and recovery, and I still have another surgery to go, but, yeah.
She came down here for surgery.
Looks like there's been substance abuse issues in the past. Showing out of Connecticut, there was a failure to.
Don't say anything right now, ma'am.
Okay.
2017, there was a failure to appear, and that was on a DUI that she was convicted of. There was also. Another prior DUI, Your Honor. Sorry, and then a previous contempt of court violation of a protection order. Nothing further, Judge.
All right, I'm gonna leave the bond at $1,000, okay? All right, Whittling Ermat.
She's approaching, Judge, here in a minute.
Okay. All right, Ms. Ermat is before the court on charge 1, false ID given to law enforcement officer. Count 2, possession of heroin. Count 3 is a felony capus with a no bond hold and not for magistrate. The court finds probable cause. The bond on count 2 is $1,000. And Ms. Ermat does have court tomorrow before her division judge. Lupaz Bracha,
I believe Paul Ryan, Judge.
Good morning, Your Honor.
Good morning, ma'am. You are before the court on charge 1 is possession of cannabis 20 grams or less. Count 2 is possession of THC, and the court finds probable cause.
Judge, if she doesn't have too bad a record, I'd ask the court to consider either an ROR or an ROR with pretrial release.
All right,
Your Honor, she has no priors.
okay,
I'd ask for a straight ROR, Judge.
all right, so I'll RR Ms. Bracha on these two counts.
Thank you so much, Your Honor.
You need to make sure you pay attention to the mail so you know if you have to come back to court.
Thank you so much.
Okay.
Yeah, don't miss court.
I will. Have a good day.
You
Okay,
too.
good luck.
Tony Lewis?
She's approaching, Judge. She's here, ma'am.
All right, Ms. Lewis has, the charge one is non-compliance with reporting to with registering, and count two is a writ of arrest with a purge amount for child support. The court finds probable cause, and I'll hear from the parties as to bond.
Your Honor, the state would ask for a $10,000 bond on count one. Here, the defendant has a Indiana address, born in Indiana. She was extradited from Indiana for this case. She also has a prior failure to register conviction in Broward County in 2009.
Okay.
Judge, that is correct. Ms. Lewis was extradited from Indiana. She lives specifically, I believe, in a city called Pekin, Indiana. She lives in an RV. She's right now in the process of applying for disability. Now, she does have family, specifically her mom, that helps her out financially as far as until Ms. Lewis is successful as far as obtaining disability. Now, Ms. Lewis and her mother, my understanding is speaking to Ms. Lewis, found out about the warrant. What she informed me, they were actually trying to contact the clerk's office to try and see or find out information as far as who were judges to make arrangements to come down here. From what Ms. Lewis advised me, no information was given to them. Nothing showed up in the system. She even advised me that she tried to call the state attorney's office to try and find out about this case so she can make arrangements come down here. She was informed nobody could give her any information about this outstanding case. But she was picked up, I believe, when she contacted law enforcement for some other reason in Indiana. Right now, her mother's the only person that can help her out. My understanding is her mom is employed with doing some sort of construction. Judge, as you can see, there's a writ of arrest, and that's not for magistrates. She's in arrears, $682. Judge, she's not in a position to post a $10,000 bond, which the state has asked for. I'm asking the court to consider a $2,000 bond on Ms. Lewis' behalf.
All right, at this time, I'm gonna impose $5,000 on count one, okay? Tomika Ozentoval,
Yes, ma'am.
all right, ma'am, you are before the court because there's an out-of-state felony hold, out of the state of Texas, and it is a no bond hold. You will be going before the extradition court next week. I think maybe Tuesday, okay?
Do you know what court is in? I was in Columbia. I had surgery. All I did was rent a car from somebody.
All right, ma'am, don't talk about your, this is a charge out of Texas.
Do you know what county?
I don't know what county. I only know it's out of the state of Texas.
I imagine that will all be provided to her at her extradition.
So when you go to the extradition judge, they will
Yes,
give you, all that information will be provided to you, okay?
Yes, ma'am.
All right, good luck.
And I'll call your mom and your son for you.
Thank you.
All right. Earl Grant. You know Earl Grant?
Judge, medical reset.
Okay, Mr. Grant is a medical reset. Caleb Filial.
Mr. Filial is approaching, Judge. He's here, remain.
Sir, you're before the court this morning for one charge of aggravated battery where the victim is pregnant. You should have known that the victim is pregnant. The court finds probable cause. And I hear from the parties as to bond.
frankly, I don't know if he has criminal history or not.
Okay.
Based on the allegations, I'm requesting a $7,500 bond and no victim contact.
Judge, normally I would think that would be reasonable, but I just spoke with Mr. Filial. He believes he can come up with half of it, so I'm gonna be requesting half of that amount. Judge, he does have limited contact with the criminal justice system. He's 24 years old. He's working, he's works at Anthony's Pizza. He's been there for about 1 month now, making $13 an hour. He'll reside separate and apart from the alleged victim. He'll live with his father. My understanding, Judge, is right now at the apartment that they were living, my understanding is their rent was about $1,000, which they were sharing and dividing equally. So he's not in a financial position to post the amount that the state requested. That's why I requested half of that.
All right, I'm imposing a $3,500 bond, no victim contact until further order of the court. Samuel Davis.
Mr. Davis is here at main, Judge. He's approaching and he's proceeding pro se, Judge.
All right, Mr. Davis, do you have private counsel?
No.
Okay. All right, you are before the court today for 1 count of domestic battery by strangulation. The court finds probable cause. Is there something you wish to say in regards to setting your bond? Not to talk about the case, but to talk about anything that you want to tell me for consideration to set your bond.
I need to get back to work, and I got a child that's in the hospital right now. What's in the plantation hospital right now? I need to go to see. And basically, yeah, I need to get back to work, take care of my house.
Okay. State?
Your Honor, I don't know if he has criminal history. I am requesting a $7,500 bond, no victim contact, based on the allegation of strangulation.
Did you say no criminal history?
I don't know. if
You
he
don't
does or
have
not.
any? Okay.
No, excuse me.
Yes, sir.
I don't have that type of money right now. I get at least.
All right, at this time, I'm gonna impose a $3,500 bond, no victim contact. Sir, that means no phone calls, no text messages, no social media until further order of the court, okay?
Okay.
All right. Marvin Miller?
Judge, Mr. Miller is here present and he also declined the public service of public defense.
Okay. All right, Mr. Miller, you are before the court for 1 count of aggravated assault with a deadly weapon, domestic violence, and the court finds probable cause. And, sir, are you planning on hiring private counsel?
No, ma'am.
Okay.
But I don't get a chance to explain myself, and I don't know what this is all about because I didn't have a weapon, nothing at all.
Sir, I'm going to stop you right now, tell you not to talk about your case. This is first appearance, and so this is not your trial or a hearing. The only purpose of this hearing is for me to find probable cause and to set your bond. Anything you say on the record can and will be used against you at a later time. Okay? So, since you don't have an attorney, is there something you wish to tell me in regards?
Yes, I have attorney on the case.
Who's your attorney?
It is Dave. I don't remember his last name, but his name is Dave.
When did you hire this attorney?
I have a court date coming up for the 3rd.
So that attorney, was that attorney retained for this arrest? You may have an attorney representing you on another case, but is he representing you on this case? This is a totally different matter.
Okay, I didn't understand.
All right. So, State, do you have anything that you wish to say?
Yes, ma'am. As, and Your Honor, it's referenced in the probable cause affidavit, he has a pending domestic violence against the same alleged victim. That was a result of summons. Your Honor, I would also note the victim in this case is advised that she is in fear for her life and that the violence in the relationship is ongoing and escalating. I'm requesting a $15,000 bond, no victim contact, pretrial release with a GPS monitor.
Do you know if there was a no contact order in place on the pending case, the other case?
Your Honor, one moment. Your Honor, I don't see one, but then again, I don't know that he's ever even appeared before the judge, because there was a issue summons. His attorney entered a written plea of not guilty. I don't know if there's been a waiver. I mean, he should have had to appear before the judge, but I don't know that he has.
Okay. All right, so at this time, sir, I am going to impose a $15,000 bond. If you are able to post your bond, you're gonna be on a level 2 pretrial. You are to have no contact with this victim. That means no phone calls, no messages, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
Okay. All right. Okay, good luck. Nicholas Hernandez.
Judge, Mr. Hernandez is approaching, and also he declined the service of public.
Okay. All right, Mr. Hernandez, you're before the court on one charge of aggravated battery, where the victim is pregnant and the court finds probable cause. State.
One moment, Judge. Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. This is based on the allegations of this case. Also, at the time of this offense, Mr. Hernandez was out on bond and is currently out on bond for possession of cannabis with intent to sell or deliver and resisting without violence before Judge Weeks.
When was the,
He posted bond October of last year.
okay. All right, so at this time, Mr. Hernandez, is there anything that you wish to say before I make a decision as to the bond?
Okay.
Not,
I was previous.
don't talk
I know
about
I'm
your
not
case,
gonna-
okay?
I'm not. I
Okay.
promise. I was previously employed. I had two actually brand new jobs in the same day. I was gonna work a double. They picked me up early morning. I really have no money. I started living with my mom again. I was living with my sister. You know, she held me down for a while, but I'm trying to rebuild my life. You know, because weed is not gonna get me nowhere selling it all day. So I need to get an actual mechanic job and a
Yes, no,
delivery job.
weed is not gonna get you anywhere. You're correct about
It
that.
really So that's where I'm at right now. It's just that I would love to pay, whatever bond it is. It's just I need to get the money first, honestly.
Okay.
The mechanic job didn't even tell me how much I getting paid. It was my first day, and they just picked me up. So I do apologize.
Okay.
Treat him good. I'm gonna get this case treat real good, okay?
Oh, and also another thing, ma'am. For the Phaleus capias,
Whatever you can do, we appreciate it.
I didn't get any papers in the mail, so I would want my address to be changed or something because I didn't get anything from the courthouse.
All right, well, that's something that you have to deal with. So at this time, I am going to impose a $7,500 bond and no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am, I do.
All right, sir, good luck. Kyle Paul.
These right here.
North Broward. All right, Mr. Paul is before the court on a resisting without violence. Does Mr. Paul have priors?
No, Judge.
Mr. Paul, are you interested in resolving this case today? Mr. Paul,
Yes, ma'am. I mean,
Do-
yes.
are you interested in resolving this case today?
What does that mean?
Well, I think probably the state will offer you a time-served plea if you wish to resolve the case today.
Nah, I'm trying to get RR because that's not nothing that like.
All right, that's fair enough. I'd ask you to ROR him, Judge. He's got
All
no
right, I'll grant his
priors.
ROR.
Thank
Okay?
you. Don't miss court, Mr. Paul.
You need to make sure that you come back to court. Roland Basto. I'm sorry, Ronald Basto. Ronald.
Judge, medical reset.
Medical reset for Mr. Basto. And Kyan Johnson.
Mr.
Kian?
Johnson is approaching, Judge. He's here at Maine.
Okay.
Come on up, sir.
All right, Mr. Johnson, you're before the court for, one is an expired tag less than 6 months. That's not for magistrate. And then count two is a traffic KPS. What does Mr. Johnson wish to do?
Judge, I speaking with Mr. Johnson earlier today. He wishes to resolve this matter today.
All right, do you have an offer for him?
Time served, Judge.
All right, it's a time served. Do you wish to accept it, sir? All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, Your Honor.
Okay, you can put your hand down. And Mr. Johnson, do you understand everything that's going on here today?
Yeah, again, time served for the KPS.
Yeah, okay. Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol? And you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right?
Correct.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, correct.
What plea do you wish to enter, Mr. Johnson? Guilty or no contest?
No contest, Your Honor.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. Devontae Wilcox,
He's in North Broward, Your Honor.
North Broward.
I was going to ask if perhaps confinement status could let us know if his bond has been posted.
Okay. No, it's not showing. Is it?
Mr. Wilcox advised me that his mother is going to be posting his bond, and I have her phone number, so I'll be contacting her.
All right.
I'd ask
so
the court to leave the bond in
We'll
place.
leave the bond in place. Good luck, sir. Brandon Sanguine. Also North Broward,
And
sorry.
he would like to resolve this if possible this morning, Your Honor.
All right. Mr. Sanguine, you're before the court for petty theft is count one. Count two is a misdemeanor KPS, also on a petty theft charge. So, on this one, it's taking beer and ice, but I don't know what the KPS, the circumstance of the KPS. State, would you have an offer on,
Your Honor, he has no prior, so I'd offer time served.
okay. All right, so Mr. Sanguine, if you, excuse me. If you wish to resolve your case, the sentence will be adjudication and time served on both.
Yes, ma'am.
All right, and just so you understand, these are two petty theft charges that you're resolving today. A third one, you could be facing a felony charge, even if it's $2 on the theft. Do you understand?
Yes, ma'am.
All right.
Yes, and we did talk about that, Judge.
Okay, all right. Do you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And am I pronouncing your name correctly? Is it Sanguine?
That's correct.
All right, so Mr. Sanguine, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
Absolutely not.
Do you need any more time to speak with your attorney?
Nope.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Absolutely not.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, so your options are at this time to, you can plead guilty or no contest. What plea do you wish to enter?
No contest.
I accept your no contest plea. You find that it's freely and voluntarily given. On both counts, your sentence is adjudication and time served. Good luck, sir.
Thank you.
All right. Yorick Scott. Yorick Scott.
I believe medical loan.
Mr. Scott is on medical loan. All right. Brandon Ivory.
Judge, I've been advised he's in regular court.
All right, we need to reset Mr. Ivory. Thank you. Bronson Gianetti.
He is here present, Judge. Mr. Giannetti, come on up, please.
All right, Mr. Gianetti is before the court this morning. These are additional charges. Charge number 3, grand theft. Number 4 is fraud, attempting to use the ID of another person without consent. Count 5 is exploitation of the elderly. And then count 6 is a felony violation of probation, and that has a no bond hold. Mr. Gianetti, you do have court tomorrow on your felony matter before your division judge. I find probable cause. Your bond on counts 3 and 4 are $1,000 each. And we need to set a bond on count 5.
Judge, my understanding, as you can see, has a no bond hold. I believe he's being held on other matters, in which one of them is also a no bond hold. So I'm asking for a $2,000 bond on count 5, Judge.
Your Honor,
All
the
right.
state would ask for 5,000 and no victim contact is based on priors and the facts.
All right, I'll enter a $2,000 bond at this time, okay? All right. Johnny Egan. All right, Mr. Egan, you're before the court. This also is an add charge, number 14, for failure to register. The court finds probable cause. I don't know, what are you asking for?
Your Honor, we're going to ask for $5,000. He has multiple no bond holds for violating pretrial release on 3 separate felony cases.
All right, so impose a $2,000 bond on this count, okay? All right, good luck, sir. James Smith.
North Broward.
I don't
I'm okay, how are you?
Okay, ma'am.
All right, you're before the court this morning, Mr. Smith, for 1 count of possession of cocaine. It's a 3rd-degree felony. The court finds probable cause. Does Mr. Smith have priors?
Yes, Judge. He has a paraphernalia from 2018, cannabis and paraphernalia from 2018, and a cannabis from 2005, and then other unrelated charges.
Okay.
It's certainly not the most heinous criminal history we've heard, Judge, and if, from what I understand, Mr. Smith is not going to be able to afford to post a $1,000 bond, I'd ask the court to consider releasing him to pretrial release.
Please.
All right, I'll RR Mr. Smith to pretrial with random drug testing. Okay? All right, good luck, sir.
Don't miss court, Mr. Smith.
Joseph Parker.
Mr. Parker's approaching, Judge. Come on up, sir. He's coming up, Judge.
Mr. Parker, you're before the court this morning. Charge 1 is resisting officer without violence. Number 2 is escape or attempting to escape. Number 3 is municipal ordinance violation. 4 and 5 are out-of-state felony holds, and those are no bond holds for the state of Colorado. So the court finds probable cause, and we need to set a bond on count 2.
Judge, as you see, he has no bond hold in counts 4 and 5. He's not going to be going anywhere anytime soon. He's the co-defendant. Judge. Your Honor knows the facts. My understanding is Mr. Parker is not working. We're going to be asking for a photo order so we can photograph the injuries that he sustained as a result of his interaction with law enforcement. But I'm going to be asking for a $1,000 bond on count 2.
And Your Honor, you know the facts. The state would again ask for $5,000 just based on the fact that he ran from police.
All right, on this, under these circumstances, I am going to impose a $2,000 bond on count 2, okay? Juan Quintana. All right, Mr. Quintana is before the court. Charge 1 is burglary, unoccupied structure unarmed. And number 2 is grand theft, and the court finds probable cause. All right, I'll hear from the parties.
Your Honor, we'd ask for $5,000 on count 1. On December 13th of 2018, he pled to a petty theft and trespass. Basically the same facts as this case where he entered a fenced area of Home Depot and stole 36 pallets. Similar facts.
Okay.
He's 50 years old, been here over half his life, he's 26. He lives locally in Davie. He shares an apartment with a roommate, I believe his share is about $400. We're gonna be asking for a $1,500 bond. He believes he can post bond, total bond including count 2 is $2,500. That's the reason why we're requesting that amount, Judge.
All right, at this time, I'm imposing $5,000 bond on count 1, and the $1,000 on count 2 will remain, and no return to Home Depot. Okay. Scott Ferris.
He's approaching, Judge, he's here at me.
All right, Mr. Ferris, you're before the court for charge 1 is aggravated battery causing bodily harm. Number 2 is aggravated battery with a deadly weapon. Number 3 is burglary with assault or battery. Number 4, burglary with assault or battery. And number 5 is grand theft auto. All right, the court finds probable cause. I'll hear from the parties as to bond.
Your Honor, on counts 3 and 4, the state would be asking for a finding of proof evident presumption great based on the witnesses to the incident. Then after the incident, the defendant confessed. If Your Honor is not inclined to find proof evident presumption great, we'd ask for, well, in reference to all the counts, we'd ask for a $10,000 bond on count 1 $10,000 bond on count 2, $15,000 bond on count 3, and a $15,000 bond on count 4. That's based, again, on the facts, and he does have a 2016 assault and battery causing deadly, just an assault and a 2012 aggravated assault with a deadly weapon.
And we would object to the court making a finding of proof evident presumption great at this stage, that being the highest standard of proof that we have in the criminal justice system. I know the state referenced an alleged confession given by Mr. Ferris, and in looking at the probable cause affidavit, which is all that the state has produced in an effort to meet this incredibly high standard, the only thing about any confession is actually handwritten in with words crossed out at the end of the probable cause affidavit. So since the state didn't actually provide a tape of the confession for the court to review, I think that that's somewhat suspect. I would ask the court not to make the finding of proof evident presumption great and to set bond for Mr. Ferris. And if over our objection the court finds that high standard has been met, we would ask the court to exercise its discretion and set bond for Mr. Ferris.
Your Honor, briefly, if I may, he has a 1997 failure to appear out of California and a 2014 giving false information out of South Carolina.
All right. At this time, the court will not make a finding of proof evident presumption great based on what's provided to me in this probable cause affidavit. So I'll hear from the defendants as to bond. I've already heard from the state, right?
Been here for about
That's
25
correct,
years
Judge.
now in South Florida. He's 49 years old. Right now, he's looking for employment, Judge. He was previously working. He was working at a restoration company. Right now, unfortunately, Judge, he is homeless. Right now, he's not in a financial position to post such a high monetary bond. We're going to be asking the court to consider releasing Mr. Ferris on level 2 pretrial release. He did inform me that he can find some sort of program that would allow him to stay there. But also, we're going to be requesting the court sign an order allowing us to photograph the injuries that Mr. Ferris sustained, Judge.
All right, I'll sign that order. Counts 1 and 2, $10,000. Counts 3 and 4, $15,000. Okay. No victim contact. John Pavlovich.
Mr. Pavlovich, I've been informed, I believe he was removed by compounded side.
Was he?
Yes.
Okay, so delete from the docket. Zayden Bovel.
He's here, President Judge. He's approaching. Come on up,
Okay.
sir.
All right, Mr. Bovel, you're before the court. Charge 1 is resisting officer without violence. Number 2 is driving while license suspended. Number 3, reckless driving. Number 4, failure to wear safety belt. Number 5, disobeying stop or yield sign. That's not for magistrate. Number 6 is aggravated battery. Offender knew or should have known that the victim is pregnant. The court finds probable cause. And I hear from the parties as to bond.
Your Honor,
Well,
on count
okay.
6, we'd ask for a $10,000 bond and no victim contact based on the facts. Defendant pushing her and punching her in the face, victim trying to get away. And when she tried to get away, the defendant then punched her in the face again 2 times with a closed fist.
Judge, in speaking with Mr. Boville, he's surprised by the allegations. He maintains basically those allegations are false. He's looking to having his day in court on this. Having said that, Judge, my understanding is basically he has a clean record as far as no prior felony offenses, Judge. My understanding is he's been residing here in South Florida for 3 years now. He's 21 years old. He is working. He works for a food service company. He's been there for about 1 year. He lives in Lauderdale Lakes with his mother. His mother, from what he advised me, is the person that he's going to be relying on to post his monetary bond. She works for a locksmith. My understanding, Judge, if the court were inclined to set somewhere around the neighborhood of a $2,500 bond on count 6, his mom would be in a position to post that monetary bond using the services of a bondsman, Judge.
All right. At this time, as to count 6, I am imposing a $7,500 bond, no victim contact. Okay. Jim Mayhew.
Judge, he's approaching. Come on up, Mr. Mayhew. And Judge, he declined the services of public defender.
Open them up. Everybody's feeling lucky.
All right. Sir, do you have a private attorney?
No, ma'am. I'm kind of like going through a lot. You feel me? At the same time, make my statement short.
Well, before you make your statement, do not talk about your case, okay? So if the statement is about the case, you will have another day to be able to do that. Today's not your trial, okay? So today you're before the court for 1 count of possession with intent to sell, manufacture, or deliver cocaine. Count 2 is a possession of cannabis 20 grams or less. Count 3 is resisting officer without violence. And I find probable cause, and if you wish to say anything in regards to setting your bond, I will hear that information at this time.
He just told me my bond was $2,500.
Well, you know, it can go up, it can go down, it can change, so I need to hear.
He didn't tell me all that.
All right.
He didn't tell me manufacturing and all that. I'm saying, what's my bond, man?
All right, state.
Your Honor, I'm not seeking an increase here. I mean, I would just let the court know that he does have a lengthy history involving drugs.
Okay. All right.
That's irrelevant, man.
Well,
What's my bond, man?
you may want to check your attitude a little bit and take it down. It is sir, it is relevant, your prior history and all of that. I get to hear all of that to make a determination. And certainly also your attitude when you're before the court. So, okay? All right, so at this time, your bond is $2,500 on count 1. Good luck. Garcia Hilaire.
$2,500.
Mr. Garcia is a judge. Come on up. And Judge, Mr. Garcia wanted me to see if confinement status can see if his bond's been posted.
Okay. And is it Garcia or Gracia? It says
I'm
G.
sorry, it's I'm sorry.
Gracia. Okay.
Yes.
All right. Has Mr. Hilaire's bond been posted? It's not showing yet. Okay. So, Mr. Hilaire, you've $750 bond. Okay. Steve Burke. Is Mr. Burke still on the docket? He's been deleted. Okay, that makes sense. It's been deleted from the docket. Huh? It's deleted. It's like Audric Gordon.
Bonded, Judge.
Mr. Gordon bonded. The court finds probable cause. Christopher Thurlow.
Northwell.
Thank you.
Medical reset.
All right, Mr. Thurlow is a medical reset. Brenston Dole Silma.
Bonded, Judge.
Mr. Dole Silma bonded. The court finds probable cause. John Borchardt.
He's approaching, Judge. He's here at me.
Okay. All right, Mr. Borchardt is before the court for 1 count of grand theft. And the court finds probable cause.
Judge, we're going to be requesting if the court would consider releasing Mr. Borchardt on pretrial release. Before I proceed, I'll see if the state has an objection.
Your Honor, he just has a 2009 DUI. I would have no objection to level 2 pretrial release.
That's the only thing, the 2009 DUI?
That's correct, Judge.
Judge, we're gonna be asking for standard pre-trial.
All right, I'll grant the standard pretrial at this time. ROR to pretrial. Sir, you need to make sure that you report to the pretrial office within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, Judge.
All right, good luck. Juan de la Cruz.
Mr. De La Cruz is here present, Judge, at Maine.
Mr. De La Cruz, you're before the court for one count of grand theft. It's a third-degree felony. The court finds probable cause.
Judge, Mr. De La Cruz, my understanding, I believe this incident took place at a Macy's. I understand Mr. De La Cruz has a clean record. Judge, we're asking the court to consider a straight ROR on this nonviolent offense. If not, though, Judge, he did give me the phone number of his girlfriend. I intend on calling her afterwards to post his monetary bond.
Does Mr. De La Cruz have priors?
No priors, Your Honor.
All right, these allegations are that he stole a Guess denim shorts, 2 Armani t-shirt, Guess denim shorts, Michael Kors shorts, Calvin Klein polo, Calvin Klein button-up, Michael Kors suit jacket, Michael Kors suit pants, for a total of $664.74.
He did cooperate with law enforcement, Your Honor.
And he has a clean record.
He stated it was a stupid mistake. All right, I'll release Mr. De La Cruz to pretrial supervision. Sir, you need to make sure that you report to pretrial within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest, okay?
Yes, ma'am. Thank you.
All right. Devin Andrews.
North Brown approaching.
All right, Mr. Andrews, these are additional charges. Charge 21 is grand theft. Count 22 and 23 are felony violation of probation with no bond holds. The court finds probable cause. Your bond on 21 is $1,000, and you have court tomorrow before your division judge on the violation of probation matters. Jamil Jasmine.
North Brown.
Oh. Mr. Jasmine, you're before the court on 2 additional charges, and that's for false owner info for pawn items, and then 10 is dealing in stolen property. The court finds probable cause, and your bonds on 9 and 10 are $1,000 each. Good luck, sir. I think I missed John Anthony. I'm not, don't remember what page he's on. Because we had pulled him out earlier because Mr. 25? Okay. So do we have John Anthony?
Judge John Anthony is at North Broward.
All right, Mr. Anthony is before the court on a robbery, no firearm or weapon. Number 2 is possession of cannabis 20 grams or less. Number 3 is abuse of elderly or disabled adults without great harm. And number 4 is a misdemeanor KPS, which is not for magistrate. And the court finds probable cause. Yes, yeah, thanks. All right, does anyone wish to be heard on Mr. Anthony?
Your Honor, on count 1, we'd ask for a $7,500 bond, and on count 3, a $5,000 bond and no victim contact. This defendant was arrested for trespass on June 23rd, received time served, and then 3 days later gets out and commits these offenses. I'd also note that he has a very lengthy criminal history.
Okay.
Hold it. Now, that Princeton Henry, you said 3 days later that happened? Hey, can we resolve the marijuana
not going to, sir, stop talking. We're not going to resolve anything here today. On count one, I am going to impose a $5,000 bond. And then on count two, I'll impose a $2,500 bond. And you have a $100 bond on count. Count three is $2,500, and you have a $100 bond on count two.
Hey, can we resolve those
No,
two
sir.
last-
No, sir.
No, as
Dejan Yates.
As what?
Dejan Yates.
As what?
Judge, we're gonna wait for more reading of the charge.
All right, so the court finds probable cause as to this additional charge 4. Is, how much bond is, does he
He's
have?
been in custody for about a year. I believe he has no bond holds, Judge, so he has a public defender assigned to his other case. At this time, nothing to add by the defense, Judge.
Okay,
That's correct, Judge. Judge Malika already found proof evident presumption great. The state amended the information to add this charge, so we just ask that you adopt Judge Malika's findings for this.
all right, it was, okay, so it was proof evident presumption great with a no bond hold, is that correct?
Yes, correct.
Okay, all right.
is this a punishable by life felony?
Is it? Lewd?
I don't have the probable cause affidavit in front of me, but it looks like
Oh,
it's,
no,
the
it's,
victim
so
is
this
12
one
years
is
of
a
age
battery.
or more.
No,
So
no.
I
this-
think he's entitled to a bond on this on this charge.
Okay, that's. Okay, that's why we all need to pay attention. 2 and 3 on the information is molestation, and then this, if this is the correct 4, it should be a lewd or lascivious battery. I don't,
That's correct, Judge.
how we put these things sometimes does not line up. All right, so he needs a bond on this one. It can't be a.
That's correct. My apologies.
All right. Not a problem. So this is a, all right, so on this one, I'll impose a $7,500 bond, okay?
If his no bond holds, Judge,
Yes.
that's fine.
Okay. John Branner,
Copy, Your Honor.
okay? All right, Mr. Branner is before the court. These are add charges, Mr. Branner. Count 3 is burglary, unoccupied dwelling unarmed. It's a second-degree felony, and then count 4 is criminal attempt to solicit or conspire, and that's a first-degree misdemeanor, and the court finds probable cause.
What's the probable cause of the basis? Where's the probable cause in it?
I don't understand what you're asking me. Based on the police report that I have before me, that's what I read to determine probable cause, okay? All right.
Police report?
All right, do we need to, let me hear in regards to bond, we need a bond on count 3.
Your Honor, on count 3, the state would ask for a $5,000 bond. The defendant did admit that he counseled and encouraged the co-defendant in committing these offenses. He also has a lengthy history involving theft and burglary.
All right,
Also appears, Judge, on count 1 and 2,
1 and 2.
Mr. Branner has received a county sentence. Sir, what is your release date on that county sentence?
It's in January 20th, 2020.
Okay, so you're gonna have plenty of time to go in front of your division judge
Right.
and address your bond issues there. Okay?
All right, so I'll impose a $5,000 bond on 3, he's got a $1,000 bond on 4, okay, sir?
Yep, thanks.
All right, Samuel Mosley,
He's here present, Judge. I mean, he is approaching. Mr. Mosley, come on up, please.
all right, Mr. Mosley, you're before the court. Charge 1 is possession of cocaine, number 2 is possession of PVP, number 3 is possession of drug paraphernalia. And the court finds probable cause. Does Mr. Mosley have priors?
Your Honor, Mr. Mosley is currently out on pretrial supervision in case number 1900763 CF10A. Petty theft, second degree, third or subsequent, resisting officer without violence. He was released to pretrial supervision on June 16th, 2019. At this time, we are requesting a revocation of his supervision.
Okay.
Your Honor,
Judge, sorry.
Just to let the court know, he does have numerous priors, all involving theft.
Okay.
Judge, what's here before you, my understanding is not a theft offense, it's a drug offense, and I haven't had the opportunity to review the PC affidavit, and speaking of Mr. Mosley, I believe the illegal narcotics were found in a U-Haul truck that he did not rent. He was a passenger, so it's a constructive possession case, which he is not the person basically driving, nor was he the person that rented the vehicle. Having said that, Judge, he just moved in with his grandmother. She lives at Sinstrunk here in Fort Lauderdale. My understanding is she has benefits, so she cannot afford to post a monetary bond. What I'm asking you at this time is, I know he's out currently on a felony petty theft on standard pretrial. I'm asking at this time to basically raise the level of supervision from standard pretrial to level 2, both on the case that he's out on the felony petty theft and on this drug offense, which is nonviolent, Judge, and that's what we're asking for at this time right now. Mr. Mosley, a little bit about him. He was working, he was being productive, but unfortunately he just lost his job. He was working at a call center, and now he's looking for work, so that's why we're asking for that, Judge.
Your Honor, I'm the only one that's actually taking care of my grandmother. There's 6 of us in the house. My auntie had just lost her apartment. So it's her, my 2 brothers, my uncle, and my cousin. I'm the only one that's trying to help out my grandmother. I just, like as I told my public defender, I just did my application for McFadden to get a trade in AC. As my uncle has one, he says as long as I do that, he also give me a job working with him.
All right. Well, pretrial is asking that I revoke his pretrial supervision.
And I'm asking you to raise it.
If pretrial being kind enough
Is
just
he
to
on
raise
standard?
it.
Is he on standard? Is this a standard pretrial?
He was released to standard pretrial, Your Honor.
Okay. All right. Well, on the case number 197638 CF10A, then I'm going to put him on a level 2 anchor monitor, okay? And then I'll do the same thing. It'll be the same thing on this new arrest. RR to pretrial, level 2.
Thank you, Judge.
Thank you, Judge. Thank you, pretrial.
All right. You write it in? You want how?
You correct it, and I'll just correct it.
Okay. He did. Joseph Olaya.
Copy, Your Honor.
Okay.
My Judge.
Good morning, Mr. Olaya. Why is these are change of charges. Got all these notes that says please set for magistrate tomorrow, but, all right, so Mr. Olaya, you are before the court for a change of charge. And, this is the common thing today. You were originally charged with burglary on occupied conveyance unarmed across county lines, and they have changed it to remove the across the county lines condition, okay?
Okay.
All right, so, how much bond was Mr. Olaya on previously?
It's $5,000, Judge.
All right, so I'll leave that bond amount in place for $5,000, okay?
Thank you.
All right. And then Michael Marshall,
Copy again, Your Honor.
okay? All right, so Mr. Marshall's is a little bit different. It's a change of charge from burglar with assault or battery to burglary occupied conveyance unarmed. And how much bond was Mr. Marshall previously in on?
$15,000, Judge. He also has a $30,000 bond on an aggravated battery and no bond on a violation of probation.
To be the case, Judge.
Okay, so we'll leave the bond in place at 15,000. Okay, all right, good luck, sir. Gerard Hamlet.
How you doing?
Mr. Hamlet is Maine? No? Where's Maine? No, where is he?
I'm right here, North Broward, man.
Yes, he's at North
Oh,
Broward, Judge.
it's just like there was a delay. Okay. So, Mr. Hamlet, you are before the court today because there has been a change of charge and we just need to let you know about it. When you were arrested, it was,
Misdemeanor?
was it a misdemeanor when you were arrested? No.
I don't think so.
It was a felony charge.
It's so, right, it was, so now it's a second-degree felony, that robbery, second-degree robbery, okay?
Second degree robbery with the, have you read the
Felony.
affidavit?
The second, they've changed it, when you were arrested, you were before the court on a first-degree felony robbery charge. Now they've changed it to a second degree.
For
It's still a felony. Whatever it is, don't talk about the case. How much bond did Mr. Hamlet have before?
$5,000, Your Honor.
All right, so then I'll leave the $5,000 in place, okay?
Could we reduce that to 1,000 or less, now that it's a second degree and obviously I can't pay it?
I think that's a pretty reasonable request, Judge.
Well,
Kindness of your heart.
well, these decisions I have to make based on facts that are presented to me. So does he have priors?
Your Honor, he has a prior possession of heroin and cannabis and a prior fleeing and eluding and possession of cannabis from 2017.
Okay. All right, so then I will, are you working?
I would like to go home.
Oh, who's gonna help you post your bond?
Well, if it's $100, my mother would post it and I can see you, eye to eye in court.
Well, you won't see me eye to eye, you'll see your division judge. So, I am, what were you asking for? $1,000.
Under, I don't know.
All right, I'll reduce it to $1,000. Good luck.
Thank you, beautiful.
All right, that's a new one.
That was some pretty good lawyering right there.
Arthur, is Mr. Demine still on loan?
Yes.
Okay, all right. All right, everyone, thank you. We've made it through the morning docket. I'll see you this afternoon.
I will not see you this afternoon.